Let's talk about one of the most common estate planning shortcuts out there. A parent adds their kid's name to the deed of their home. The goal? To dodge the hassles of probate court. But does this simple move, creating what's called a joint tenancy with right of survivorship, actually create a massive hidden tax trap? Well, this one little act can set off a whole chain reaction of financial problems, and we're going to break down exactly how.
So this is the big question we're tackling today. A property owner makes this move trying to simplify things for their family, but then the panic sets in. Did they just accidentally create a huge capital gains tax bomb for their kids? Did they trade a probate headache for a total tax nightmare? Let's find out. We're going to get the definitive answer by looking directly at the Internal Revenue Code.
All right, here's our game plan to get that answer. We have to follow the logic of the tax code itself. We'll start with the huge difference between step-up basis and carryover basis. Then we'll connect that to something called the estate inclusion rule and a really critical test called the consideration furnished test. That's going to lead us right to the hidden gift trap and, finally, the verdict.
Okay, first up, step-up versus carryover basis. To really get what's on the line here, financially, you have to understand this one little number, the tax basis. Think of it as the starting point, the number the IRS uses to figure out your taxable profit, your capital gain when you sell something. And how you get that property, well, that determines your starting point.
And right here, this is the central conflict. See, if you gift property to someone while you're alive, the person who gets it takes on your original cost basis. It just carries over to them. But if that exact same property is inherited after you pass away, the new owner's basis gets stepped up to whatever the property was worth on the date of death. And as you're about to see, these two rules lead to totally different tax bills.
Now, the power of this step-up comes straight from Internal Revenue Code Section 1014. And I'm not kidding, it's one of the biggest benefits in the entire tax code. What it does is effectively erase a lifetime of appreciation. An asset that's grown in value for decades can be sold by an heir for its current market price with potentially zero tax due. It's huge.
On the flip side, you've got carryover basis. This means the person who gets the gift also gets the original owner's built-in tax problem. That original purchase price plus any improvements, that's their new basis. The tax liability doesn't just vanish, it gets passed right along to the next generation. So let's look at what this actually means in real dollars.
Okay, let's put some numbers to this. Imagine a parent bought a home for, say, $50,000. Years go by, and now it's worth $500,000, $500,000. If they just gifted the whole house to their child, that child's basis is that original $50,000. So if the child then sells it, they're looking at a taxable gain of $450,000. That is the financial disaster we're talking about.
But now, check out the magic of the step-up. If that same child inherits the home when it's worth $500,000, their basis is stepped up to that full $500,000. If they turn around and sell it for that price, what's the taxable gain? Zero. A big, fat zero. That entire $450,000 of appreciation just got wiped away tax-free. So the question is, which rule applies when you just add a name to a deed? Is it a gift or is it an inheritance?
And this brings us right to Section 3, the Estate Inclusion Rule. Think of this as the bridge that connects inheritance to basis. The link that decides whether you get that incredibly valuable step-up is called estate inclusion. The rule itself is pretty simple. To get the tax benefit of an inheritance, the asset has to be included in the deceased person's estate for tax purposes first.
And here it is, the key, straight from the horse's mouth, IRC Section 1014B9. The code basically says the step-up applies to property you get through things like joint tenancy, but, and this is a huge but, only if that property is required to be included in the value of the person's gross estate. That right there, that's the bridge. So let's just boil this all down. The core principle is simple and powerful. Estate inclusion dictates basis. If the asset gets pulled into the gross estate calculation, it gets a step up. If it's not, it doesn't. You see what this means? Our entire question just shifted. It's no longer a basis question, it's an estate inclusion question. How much of that jointly owned home is included in the parent's gross estate when they die?
This leads us straight to Section 4 and the rule that literally changes everything, the consideration furnished test. The tax code has a very specific and honestly often misunderstood rule for joint property between non-spouses that's going to give us our answer.
You see, under IRC Section 2040, the tax code actually sets up two completely different paths. For married couples, it's easy, a simple 50-50 split. But for anyone who isn't married, like a parent and child, we have to look at subsection A, and that's where we find our all-important test. Okay, so here's the rule, right from the source. Section 2040A, the Consideration Furnished Rule, says that 100% of the value of the joint property is included in the estate of the first person to die, unless the survivor can prove they contributed their own money to buy the property. The burden of proof is completely on the survivor.
So let's apply this test to our scenario. It's pretty straightforward. 1, the parent paid for 100% of the house. 2, they added their daughter to the deed for $0, no consideration. 3, the daughter can't prove she contributed a single penny. So what's the result? Under the explicit terms of Section 2040A, 100% of the property's value gets pulled right back into the parent's gross estate.
And this, right here, is the paradox. It's kind of brilliant. The very rule that forces 100% of the property's value back into the parent's estate is precisely what saves the 100% step-up in basis. Because 100% is included under Section 2040A, that means Section 1014B9 grants a full 100% step-up. The probate avoidance shortcut actually works, but only because of this weird counterintuitive dance between two parts of the tax code.
So we've answered the main question. The step-up is preserved. Fantastic. But this brings us to Section 5, the hidden gift trap, because while this move solves the basis problem at death, adding the daughter to the deed creates a whole bunch of other immediate tax issues and future risks that you need to know about.
Well, under Internal Revenue Code Section 2511, the moment the parent added the daughter's name to that deed, they made what's called a completed gift. And you might ask, why? Because they gave up total control. The parent can no longer just decide to sell or refinance the home on their own. They need the daughter's signature. That transfer of a real, legal property right, that is a taxable event for gift tax purposes.
Now, that completed gift, it triggers a legal obligation. If the value of that gifted 50% was more than the annual gift exclusion amount, which is around $18,000 or $19,000 a year, the parent was legally required to file a Form 709 gift tax return. Now, most people don't actually owe tax, it just eats into their lifetime exemption. But the filing itself, it is not optional. And here's the kicker. If you fail to file, the clock never starts on the statute of limitations for the IRS to come asking questions.
And this is where the trap can spring with some really devastating results. What if the family needs to sell the house before the parent passes away? The parent, who lives there, can probably use their personal residence exclusion to wipe out their share of the capital gain. But the daughter, she doesn't live there, so she can't. And as you can see, she suddenly gets slapped with a massive taxable gain, creating a completely avoidable tax bill for the family.
Okay, let's pull all of these technical threads together and get to the final verdict. We've journeyed through IRC Sections 1014, 2040, and 2511 to get the full picture.
So the final answer is a classic yes, but. Yes, you did preserve the full step-up in basis thanks to that consideration furnished rule, but in doing that, you created an immediate gift tax filing requirement, and you've now exposed what might be your biggest asset to your daughter's potential creditors, lawsuits, or even a divorce. Plus, you've set a tax trap that could cost your family tens of thousands of dollars if you ever need to sell that property while you're still alive.
And that really leaves us with this final question to think about. The whole goal from the beginning was to avoid the complexity of probate, but as we've just seen, this simple solution introduces a whole new, and you could argue much more dangerous web of tax filings, creditor exposure, and capital gains risks. It's a powerful reminder that in estate planning, the simplest looking path isn't always the safest.